All right, picking up with our civil liberties flashcard. Let's go to the Second Amendment, flashcard number 16. Second Amendment we've talked about is a bit open to interpretation about exactly what it means. Fundamentally, we know it's related to the right to bear arms, but the flashcard asks you to describe different ways the court could interpret the language of this amendment. So if we look at the amendment, it basically has two clauses. It has what we call the prefatory clause and then the operative clause. The prefatory clause talks about the necessity of a militia as being important to the security of a free state. It's kind of this preface to then the operative clause, which says the right to the people to keep and bear arms shall not be infringed. So one of the questions is, does the right to bear arms depend on someone's membership in some sort of militia or military unit? And the Supreme Court has ruled somewhat recently, actually, that these clauses are separate. There's some disagreement over that. The case was called D.C. versus Heller in 2008, which they really articulated this clearly in a 5-4 opinion. But they basically said that the right to keep and bear arms is an individual right, and it's not dependent upon membership in a militia. It's not a group right in a militia. It's an individual right for self-defense. So that's one issue, and there's disagreements on that about what the appropriate regulations are. And then the second thing we could talk about is what are arms, right? Are we talking about arms from the 1700s? Are we talking about arms in 2020? And what's appropriate regulations there? So the Supreme Court in 2008, D.C. versus Heller, they said Washington, D.C. can't ban handguns. That would violate the Second Amendment. Others, 4 members of the court actually disagreed with that. They said D.C. actually has this right. So, obviously we know, especially in the world we live in today, in which there are so many acts of gun violence, that the Second Amendment is incredibly divisive and controversial. And there are public policy issues that are certainly debated about what's an appropriate government response to some of the things that have occurred over the past few years and decades. And there are some things the government could do within the bounds of the current interpretation of the Second Amendment. So the Second Amendment doesn't prevent certain regulations the government maybe wants to or debates imposing. So the Second Amendment is still open to interpretation, but there's still things the government can do. In Flashcard 17, we talked about the Eighth Amendment, and we specifically talk about it as it relates to the death penalty. So the question of whether the death penalty is cruel and unusual punishment is really the issue here in Flashcard number 17. The court has never said the death penalty in and of itself, just its existence is cruel and unusual punishment. Some people believe that. But what they have ruled is that it has been administered arbitrarily, and there need to be clear procedures in place for when the death penalty is going to be given and when it's not going to be given. And then in recent years, there's been questions about the method of death penalty and whether that, lethal injection, sometimes unfortunately, we've had these horror stories of it going wrong, whether that could be considered cruel and unusual punishment as well. So the death penalty is a political issue in that people have their views on it. It's certainly been things that presidential candidates have talked about, et cetera. But it is a constitutional question. But some states allow it, some states don't, and the Supreme Court, they permit it as long as states have procedures in place to make sure it's administered or given, I suppose, or used as a sentence as fairly and equitably as possible. Moving on to Flashcard 18, the concept of selective incorporation. So we go back to the beginning of the unit, actually, when we talked about how the 14th Amendment, which was added after the Civil War, it was added to basically protect the rights of newly freed slaves. But one of the things it did was it said no state shall take away the privileges and immunities of citizens of the United States, nor will they take away life, liberty, or property without due process of law. And so this no state shall element of the 14th Amendment and the due process clause of the 14th Amendment in particular, this has allowed the Supreme Court to take the Federal Bill of Rights and say, well, these are the rights and liberties of individual citizens of the United States. So now we're going to incorporate those and say no state shall take away these rights and liberties of citizens of the United States as well. So that's what incorporation is. They do it piecemeal, though. So the idea of selective incorporation is the idea that the Supreme Court selected or has selected provisions of the Bill of Rights one at a time to say this applies to the states, this applies to the states. This is fundamental. This is a fundamental liberty that someone has in the United States. So this, we're going to say no state shall. It applies to that state action as well. So incorporation, very, very important legal concept, because prior to the 14th Amendment, and really prior to the 20th century, actually, in which the 14th Amendment started to be used to restrict state actions, the Bill of Rights only applied to actions of the federal government. So states and local governments, they could restrict the rights of individuals, and they would not have been according to the Supreme Court's interpretation, in violation of the Constitution. Flashcard 19 is an example of an incorporation case. So while most provisions of the Bill of Rights were incorporated throughout decades in the middle of the 20th century, 1920s, 30s, 40s, 50s, 60s, 2010 is the last example of an incorporation case. And this was when the Second Amendment was made applicable to state and local governments in McDonald versus Chicago. So this is a required case, and it's required, I think, by the College Board in particular, because they both can talk about the Second Amendment issue here, but also about the incorporation issue. So from a Second Amendment standpoint, very similar to D.C. versus Heller, same sort of case where instead of Washington, D.C., which is not a state, it's a part of the federal government, now here we have Chicago, which is within a state. And they're trying to impose a very similar handgun ban to Washington, D.C., and the court issues the same ruling they issued in D.C. versus Heller, but now they're applying it to the states. Now they're saying this is a fundamental liberty, and it's something that we are incorporating. We're going to use the 14th Amendment to do it. States won't take away liberty of people without due process. States won't abridge privileges and immunities of individual citizens in the United States. The Second Amendment applies to that as well. Speaking of due process, okay, so flashcard 20, due process is this broad legal concept that appears both in the Fifth Amendment as well as in the 14th Amendment. Fifth Amendment says that the federal government won't take away life, liberty, or property without due process of law. And the 14th Amendment says the states won't take away life, liberty, or property without due process of law. And due process is a legal concept. It's this idea that you have broad legal rights and procedural rights. If you're going to be accused of a crime, if something's going to be taken from you, if you're going to be punished in some way, the government has to go through a process, which is called due process. The process which you're entitled to as a citizen in order to do those things. So it's kind of this legal concept of fairness and process and legal procedures. The Bill of Rights protects these. Okay, and the Fifth Amendment has the due process clause specifically in it. But broadly speaking, we look at a lot of the legal procedural rights that are embodied in the Bill of Rights as things that people are entitled to. So if we go through Amendments 4, 5, and 6, and I won't go through them all in exact detail right now, we can see these have a lot to do with the rights of people who are accused of a crime, who are suspected of a crime, or who are being charged with a crime. The Fourth Amendment, the highlight of the Fourth Amendment is that the government won't search or seize any of your persons or effects without a warrant, without a just cause. The Fifth Amendment has many different provisions in it that protect people from government overreach. They say that if you're going to be charged with a felony, it has to happen in a grand jury, which is a jury's convened to see if there's enough evidence to charge for a felony. They say that you won't be charged twice for the same crime in the Fifth Amendment. That's called double jeopardy. You won't be compelled to be a witness against yourself. And we see that's become codified through the Miranda rights that are read, and that came about because of the Miranda case. The government won't take your property without just compensation. That's the idea of eminent domain. So that's all in the Fifth Amendment. And, of course, the Due Process Clause. They won't take away life, liberty, or property without due process of law. That's in the Fifth Amendment. In the Sixth Amendment, you have rights, a lot of which apply to a trial. You have to have a speedy trial. You have to have a jury of your peers. You have to have access to counsel. And by that, we mean an attorney. So, the Sixth Amendment is very much about trials and the procedures surrounding them. So 4, 5, and 6 are kind of amendments that kind of go together. We have some required cases to talk about. Miranda versus Arizona. This was a case where an individual Ernesto Miranda was arrested, and he was not informed of his, just go really basic on these cases. He was not informed of his rights, his Fifth Amendment rights in particular, to remain silent, to not be a witness in his own defense, and therefore the Supreme Court threw out his conviction. And this is about the Fifth Amendment specifically. And because of it, we now have the Miranda rights being read. People read the rights to people before they're arrested, so that they acknowledge they understand the rights, so that anything they say then won't be thrown aside. Great videos we have access to. I showed you in class, which they go into the real details in these cases, the Miranda case in particular. There are exceptions, public safety exceptions. Certainly if somebody is deemed as an imminent threat, who has knowledge of an imminent threat, like a bomb being placed somewhere or an ongoing terrorist attack, then the court has ruled that they don't have to necessarily be given their attorney right away or being read their Miranda rights right away, and the government can try to get more information out of them. So the courts have ruled there are exceptions in the interest of safety to the provisions in the Fourth, Fifth, and Sixth Amendments. We also know that the Fourth Amendment has been controversial when it comes to things like wiretapping and government surveillance, which is what Flashcard 26 is about. The idea that, especially after September 11th, the government passed what was known as the USA Patriot Act, which really broadly increased the ability of the United States surveillance agencies to kind of have a watchful eye on its citizens and to collect data. And there remains a debate. Let's put it this way: there remains a debate about what is the appropriate role of government and what are appropriate exceptions to the Fourth Amendment, and how does the Fourth Amendment apply to the vast collection of huge amounts of data without a warrant, potentially, whether it's cell phone data, whether it's computer data, search history, Google Drives, you name it. How much of that do they really need a warrant? And that's an issue that continues to get litigated in the courts, actually, including in recent years, about location data and things like that. We have some other cases and constitutional concepts. We'll talk about Mapp versus Ohio, 1961. And I'll just give you the broad overview here in this case, which is that evidence was obtained without a warrant. Okay. And the court ended up throwing that out. And they said that they basically said, and they established, the exclusionary rule, is that if evidence is obtained illegally, if the government doesn't have a warrant, if they don't go to a judge and get a warrant and then search something with a warrant, then that evidence can be excluded from trial. So the courts, especially in the 60s, they went through a number of cases in which they really beefed up these protections that exist in the Fourth, Fifth, and Sixth Amendment. So Mapp v. Ohio would be related to the Fourth Amendment. Gideon versus Wainwright here in Flashcard 29, that would be related to the Sixth Amendment. This is about the right to an attorney. And here in the state of Florida, they didn't give attorneys for all crimes, and they said you're entitled to an attorney, you have the right to an attorney, but the state's not necessarily going to provide it to you. And the Sixth Amendment says you're entitled to an attorney to your defense, and Gideon versus Wainwright says, well, actually, they need to provide one for you. That's legally required under the Sixth Amendment. So now you're entitled to attorney if you've been charged with a crime, and that's a precedent that's set in Gideon versus Wainwright. Flashcard 30 and 31 deal with the right to privacy. And the right to privacy is a very complex legal concept we talked about in great length in class. Okay, this is a reminder. This is just a quick review. But the idea that people have these zones of liberty, these penumbras, as we called it, these shadows, that the Bill of Rights kind of endows on people, that's been used to expand individual rights to a legal concept known as privacy. The first time this was articulated was in Griswold versus Connecticut, in a case in which the Supreme Court struck down a birth control ban in Connecticut that applied to married couples. This was in 1965. They struck down this old law from the late 1800s. And what the Supreme Court said is if you take the First Amendment, the Third Amendment, the Fourth Amendment, the Fifth Amendment, the Ninth Amendment, and the 14th Amendment, all these amendments, they don't say you have the right to privacy explicitly, but they all imply broad liberty rights, including rights against government intrusion in your private affairs. The due process clause of the 14th Amendment, that's, first of all, due process we've talked about, but it has that no state shall. So, you've got due process in the Fifth Amendment, you've got due process in the 14th Amendment, and now you've got states won't take away these rights either. So all of these amendments together, they play a role in kind of establishing your constitutional right to privacy. But that's not always consistently agreed upon about whether or not these amendments actually create this right. And the most controversial, of course, being Roe versus Wade, the most controversial privacy case out there, in which the court basically said a woman's right to an abortion is constitutionally protected because it's a right to privacy issue. And this is something that people disagreed with disagreed over at the time. And of course, we know continue to disagree over today. And the makeup of the court has shifted. So people wonder if a case similar to Roe came before the court where a state tried to ban abortion, would that be struck down, or would that be upheld? And could a Roe versus Wade be overturned? The basic facts of Roe versus Wade, which is a required case for the AP exam and for our unit, is that Texas had an abortion ban. The abortion ban was challenged as a violation of constitutional rights. Constitutional clauses involved. I just listed all the different amendments that could be included in the concept of the right to privacy. And of course, we know the precedent that abortion is constitutionally protected under the Constitution. And people don't all agree with that, including more conservative justices who maybe have tilted the court a little bit more to the right. So that might be something that will be litigated or continue to be litigated in the future. So there's a lot of information in our Civil Liberties unit. I've gone through a lot of flashcards in these two videos. I hope it was helpful. And again, these are starting points, not ending points for your studying. Make sure you go back through our lessons and all the materials we have. And let me know if you have any questions. Have a great day.